guys here. I think we introduced ourselves here.
Hey, Sam Aswell.
Yeah, that's basically what you guys need to know. So the plan for today is that first, Chris and I will do a brief little exhibition moot. It's not on the facts you guys have got. We didn't want to do that to you, so it's on a different thing, but it's straightforward enough. All the facts fit onto one nice little PowerPoint slide. Hopefully you guys will be able to follow along and see what it looks like. Then there's your guys' workshop, which I'm looking forward to. I hope you're looking forward to. And then after that, Renae should be here to give a talk about mooting in general and answering questions in particular, I think.
Dr Renae, as we can now call her, after her recent graduation, so congratulations to her for that too.
Yourself. Alright, good.
So speak of facts. As you said, fit onto the slide might be generous.
Can everyone see that okay?
If you can't read it, I could, to assist the court with a brief summary of facts.
Please do.
Yeah. So, my client, Lord Dixon, was accused of the violent murder of his partner. His judge-line trial was held before Justice Harvey of the Supreme Court of Western Australia. Towards the end of the trial, my client thought he recognised Justice Harvey and realised that they had attended school together over 20 years ago. In September 2013, Dixon was found guilty of murder and sentenced to life in prison by Justice Harvey, which was the maximum sentence. It would be hard to give a higher sentence, I suppose, than life in prison. There you go. Dixon, my client, then remembered he bullied Justice Harvey at school, fortuitously. Dixon, 2 years older than Justice Harvey, recalled that he had often given Harvey a beating for no good reason. He had a vague recollection that Justice Harvey may have spent time in hospital as a result of one beating and may have been taken up in school by his parents. My client appeals his conviction, and in November 2013, the Court of Appeal held by 2-1. The test was whether a fair-minded observer might entertain a reasonable apprehension of bias about Justice Harvey. And this involved the two-stage approach adopted in Emder and the official trustee in bankruptcy, recently approved by the Court of British American Tobacco. And as the bullying events occurred over 20 years ago, a fair-minded observer would not have a reasonable apprehension of bias. That's what this case is about, an area of law referred to as natural justice. So if a judge has as I'll tell you in a second, a reasonable apprehension of bias,
let's say for sufficient.
they're required. Let's get that in there. Dixon has, of course, been granted special leave to appeal to the High Court of Australia, which at this stage is made up by a quorum of 2. The other one's apparently having lunch. But actually, does anyone want to join in as a judge? I'll give you the option to be the third member of the panel if you want.
What we have to do is ask us questions and try to trip us up.
Yeah, you've got Nigel and Ciara that's alongside you, so you'll be able to keep up with the stand.
Jump in, Sam. Go on. Right, well, people at the back, feel free to get an actual seat with the table somewhere.
Yeah, no, do come up. You don't need to sit right up.
Yeah. Don't want the room set up. If you just want to jump over there, maybe with Ciara. Or just so you're not blocking the view of anyone. If you make
Going to that.
Oh, yeah. If you want to make us do appearances first, that's probably smart. Yes. Let's do that. Do you want us to bring your table closer? That'd be helpful.
Are you guys going to swing up there?
Yeah. Even if you just swing that around a little bit.
Yeah.
Judicial dignity.
May I please the court? My name is Birch and I'm here on behalf of the appellant.
May it please the court, my name is Sam Aswell and I'm here for the respondent, the state of Western Australia.
Yes, Mr. Birch.
Hi.
Just in time. Some things linger in your mind no matter how much time passes. Abuse suffered in school at the hands of an older student is one of these things. And that is the case before the court today. The court must decide whether a reasonable person would believe that a series of violent assaults by the appellant upon Justice Harvey could be forgotten, or whether such assaults raise doubt about Justice Harvey's impartiality when he found the appellant guilty and sentenced him to life in prison. I'll have 2 submissions for this case today. My first submission is that a fair-minded observer might have reasonably apprehended that Justice Harvey did not have an impartial mind in deciding the appellant's guilt and sentence. My second submission will be that the public confidence in the administration of justice requires judges with this kind of apprehended personal animosity towards a defendant to disqualify themselves from trial, and this outweighs any other policy interest. Moving then to this first submission, that a fair-minded observer might have had a reasonable apprehension that Justice Harvey did not have an impartial mind in deciding the guilt and the sentence of the appellant. A judge is required to disqualify themselves if a fair-minded lay observer who is neither complacent nor sceptical, a reasonable person, if you will, might have reasonably apprehended that the judge has not brought an impartial mind to the decision they are making. That statement comes from Ebner and the official trustee in bankruptcy from the year 2000 in 205 Commonwealth Law Reports 337 and paragraph 23, and if I may dispense with full citations, Your Honours.
You can, Mr. Birch. Mr. Birch, that case dealt with, well, it was an appeal here in two cases, and both involved matters where the judge had shares in the ANZ Bank. Is the test the same where we have a category of, the argument is that there's an apprehension of bias due to association between the judge and the appellant? Is the test the same in this case as it was where we're dealing purely with pecuniary interests?
We submit to the court that the test is, in fact, the same between these two cases. The difference that is material for this court is how the circumstances go to show that reasonable apprehension of bias. And in fact, we'd submit to the court that in cases where there is a personal relationship, particularly one of abuse between the judge and the defendant, that would make it easier to establish this reasonable apprehension of bias, that there would be a lower bar to that than in cases where there were, say, barely connected financial interests, as was the case in Ebner. The judge held shares in a couple of companies that stood to benefit to some extent from the decision in that case.
Do you have any authorities for this proposition, Mr. Birch?
Fortunately, it has not come before the courts before that a judge has been assaulted by the defendant in the case.
Personal interests, generally speaking, as opposed to pecuniary interests?
I believe in those kinds of cases, judges have generally recused themselves well beforehand, having been aware of these kinds of circumstances, and for that reason there does not appear to be an authority exactly on point in this case. But we submit, of course, that the test is the same. It will simply be a lower bar to establish it, given the personal relationship we're identifying today.
Mr. Birch, is there any evidence that this has actually in fact happened? You seem to be making your submissions on the assumption that in fact the appellant has previously assaulted the judge, but the wording of the facts seem to make this very vague, and in fact it could well be a case of mistaken identity. Is there any evidence apart from the appellant's recollection?
It does not appear so, Your Honours, in this case. What I would say, though, to that is that the mere fact that this has been raised in evidence is enough to establish that a reasonable person would have an apprehension of bias had this happened, and that this is enough to establish that there was a miscarriage of justice requiring a retrial.
Mr. Birch, how do we know that the appellant is not just making this all up?
We know that, Your Honour, simply because the appellant has, of course, sworn this under oath, and it is to be taken unless contrary evidence shows otherwise that that is the truth in this case. There has been no evidence raised to say from the respondent that this is not true, that Justice Harvey had no knowledge of this person. This kind of evidence could, of course, have easily been shown, say, if the two never went to school together.
So you're asking the court to infer from the fact that the respondent has not raised any contrary evidence that we should take the evidence of the appellant without on face value, as vague as it is.
That is true, Your Honours.
Mr. Birch, is it not possible that a fair-minded observer might accept that a justice of the Supreme Court of Western Australia would be measured, objective and professional in their sentencing and judgment?
That does in fact take me to my second submission, and I'll move briefly to address that point now. there's a competing policy interest between judges doing their duty as professionals in these cases and the administration of justice itself. Justice must not only be done, but seen to be done as well, so that people have confidence in the system. That's from Johnson & Johnson in paragraph 12. What we say here is that duty of judges to hear cases is overcome where they could not possibly be seen to be impartial, and that the public administration of justice requires, in cases where a personal relationship of abuse with a defendant in a case means that a judge could not be seen as impartial by a fair-minded observer. I'll move back now to consider the... Yes?
The standard which you're raising here is whether or not a judge could not possibly be seen to be a fair-minded observer. What threshold would you propose in terms of the number of years, which, say for instance, the number of years that must pass between the events at issue and the judgment? At what point is a judge able to, is the public able to apprehend that a judge would disconnect themselves from the events of the past and to approach the case with an impartial mind, as opposed to not approaching the case with an impartial mind?
I'd say, Your Honour, that depends entirely upon the nature of the offence itself. So in cases where, say, there had been a violent assault, as this one, or potentially a sexual assault, say, there would be no reason to believe that the judge would ever be able to bring an impartial mind to that case. It would always have some animosity towards the person who had committed that act of violence against you. That is not a bar to deciding the case in the favour of the appellant here. What that means is, of course, that the judge should have recused himself, or during the trial should have been disqualified from hearing it. And given how few cases this will arise in, that poses no problems for the efficiency of justice or the allocation of judicial resources to the hearing of cases.
Mr. Birch, the appellant here only remembered his vague recollections of the events towards the end of the trial. It's entirely possible, in fact probable, that the trial judge here didn't recognise the appellant, given that he didn't recuse himself, he didn't make any comments about this, and taken judicial notice of the number of cases he'll be dealing with. To what extent does, assuming the judge had no knowledge, forgotten that this is the man or didn't recognise him, how does that factor into the test that you proposed?
So the question then is how that appears to a fair-minded observer, of course, and I'll address that now. It matters not at all whether the judge did or did not know the appellant in this case, merely how it would appear to a fair-minded observer.
So does the fair-minded observer have knowledge of everything that's happened, or simply what people at the time remember as happened?
They are taken to have knowledge of all the facts of the case as it is at the time the request for disqualification arises. So in this case,
irrespective of whether everyone in that courtroom knew of what happened, is the fair-minded observer taken to be godlike?
Not godlike, Your Honour, merely aware of the facts that have arisen that lead to the request for disqualification. In this case, the facts that surround the instances of bullying in high school. So looking then to what a fair-minded observer would have appreciated in this case on the basis of those facts, they would have known that Justice Harvey was bullied by the appellant at school, and that this was not merely matters of teasing, but rather a prolonged and regular series of abuses, which included violent beatings leading to the hospitalisation of Justice Harvey. So bad, in fact, that Justice Harvey was taken out of that school by his parents. That's what's alleged on behalf of the appellant.
May have been.
May have been. That is the evidence that is raised by the appellant and not refuted by the state. What this establishes then is that Justice Harvey would have been aware of this information, or that a reasonable person, a fair-minded observer, would have appreciated that he should have been aware of this information. That would be enough then to show that we can move to this second.
What if a fair-minded observer was cognizant of the fact that Justice Harvey had apparently not recognised this person at all? What if a fair-minded observer had taken into account that, despite the events which had happened prior, because Justice Harvey may not have actually recognised him, cite the fact that he recognised the person or recuse himself or anything like that. Is that relevant to your analysis then? Because this is reasonable apprehension of bias. And if it would be apprehended that the justice in this case didn't actually recognise the person for them, then surely that would negate your claim.
That's certainly one conclusion that the court may draw. On the other hand, an equally open would be that Justice Harvey knew exactly who he was and knew that this was his opportunity to, as it were, get back at the defendant.
But there, Mr. Birch, you're raising actual bias, aren't you?
I'm not. I'm merely raising what a fair-minded observer might consider to be the case in the mind of the judge, which is perhaps a long way around getting to the point, Your Honours, but at the same time is certainly something that a reasonable person could have seen in this case. And in fact, I would suggest is likely to have been the case, given that individuals are perhaps not as aware of the duties of judges as they may otherwise be.
So, Mr. Birch, to clarify, it's only necessary then that a observer would apprehend that there is a chance that the decision maker could be bringing some bias to the case due to the way the circumstances arise. Is that your submission?
The word used in Epner only this possibility, but I think chance would equally satisfy the test here. So then it is a matter of looking to the second limb here, once we've established that there was a matter about which the court can take notice, is that there was a logical connection to a feared deviation from making a decision on the basis of the facts and the merits of the case. As I've already submitted to this court, there are some things that time simply does not heal. This includes the lasting impact of childhood bullying, as I said in response to your question, Your Honour. In this case, there could be two ways that there would be an apprehension of bias. Either that Justice Harvey's decision was influenced by his dislike of the defendant at the time, so that he had an actual bias in that sense, or that he improperly took into account as character evidence what he knew of the defendant in that case, and that either of these are apprehensions of bias that would have been open to a fair-minded observer. What this establishes then is that there is a connection between the bullying and the apprehension that his decision may have deviated from one made purely on the legal and factual issues.
Sorry, Mr. Birch, on that second factor, character evidence, judges all the time, particularly in the case where a judge is sitting on trial himself rather than a jury, judges routinely have to distance themselves or ignore information that they may have seen in news reports. How does that mesh with your submission that this judge may not have been able to distance himself from that extra information when he's determining what sentence he should impose?
I say, Your Honour, that it's not simply extra information, say having a good knowledge of the past of a defendant that might come, say, from news reports like in the case of Renae recently in Western Australia. Rather, it is a personal connection to that extra information, that where you have been personally violently abused by the defendant.
That really flows back into the first category that you gave, and that was dislike.
Certainly, but you would be more likely to take it into account as character evidence wrongly in that situation with the personal connection that existed between the judge and the defendant in that case. In either case, knowing about that would be enough for a fair-minded observer to apprehend that the justice would have taken this into account as character evidence, that he would not have been able to set it aside in his mind.
Mr. Merton would have taken this information into account as character evidence, or was likely to have taken this? Does it matter whether or not there's a certainty of an improper decision or just a likelihood?
I may have set too high a bar for myself. I submit that it is simply a likelihood, the possibility that this would have occurred, as it were. That does draw me to the end of the first submission then, that because there was this other matter and because there was a logical connection with a feared deviation from a decision of the actual facts and merits of the case, that is enough to establish the judge should be disqualified and the conviction quashed and a retrial ordered.
Sorry, Mr. Birch, obviously one of the pivotal factors here, and I presume Mr. Pack will be making this submission, is that 20 years have passed since the events. Plenty of things happen to kids when they're young. But now you have a judge in the Supreme Court sitting on this case. why do you say these particular circumstances give rise to a situation where the judge can't bring an impartial mind?
As I submitted to the court, there are some things, violent offences, for instance, that no amount of time can place outside the mind of the person. We will all remember that someone has done that to us. And this was a particularly serious instance of that. There was a hospitalisation involved. This judge was taken, at the time this child was taken out of the school he was attending. These aren't things that pass from someone's mind over the course of 20 years or even the course of a lifetime. And that is why, for this court, the decision is about should that judge in particular have been sitting on this case, or should, before this case even came to be allocated to that judge, another have taken it in his place. That is what the court must decide today.
So, what things would pass from a person's mind over a period of time?
Many things, Your Honour, speaking from personal experience at the least. People's phone numbers, people's birthdays certainly don't seem to stick around terribly long for us.
Sorry, Mr. Birch, I need to clarify. In terms of whether or not there would be a reasonable apprehension of bias, at what threshold of personal abuse would you set the level of things being able to pass from someone's mind?
I submit to the court that it is some time before we get to violent assaults. It may involve, say, minor thefts or various other forms of offences against property, say, and certainly ones that include this kind of serious assault with hospitalisation would be well outside any area that could be dispensed with over a period of 20 years. I believe at this stage I have established my second submission to the extent I wish to, and noting time, that will conclude my case unless Your Honour has any further questions.
Thank you, Mr. Birch.
Thank you.
How long did you end up talking for?
15, Sam. Just 15.
It's not too bad. I gave him 8.
Yes, Mr. Pack.
Thank you, Your Honour. So Mr Dixon is appealing against the Court of Appeal's decision to uphold his conviction for the violent murder of his partner. Mr Dixon alleges that the trial judge, His Honour Justice Harvey, should have been disqualified for the apprehension of bias. The respondent largely agrees with the appellant's characterisation of the relevant law here. The relevant test as to whether Justice Harvey should have been disqualified is the two-step test laid down in the case of Edna and the official trustee in bankruptcy. Before I turn to the application of that test, I'll just make a few preliminary points. The first is that that test is the test for all cases of apprehension of bias, whether that's by association, by interest, even to the extent of a violent assault. This can be seen in the case of Edna in paragraph 28.
Yes, but Mr. Pack, in the later High Court case, the tobacco case, the court there did say that particular applications of that general principle will be required for the different classes of case, which include association, in which an apprehension of bias is said to arise in different sets of circumstances within those classes. So the test still needs to mesh with the particular class of case we're dealing with, whether that be pecuniary interests or association.
I'm afraid I can't speak to that particular passage of Johnson, Your Honour. All I do know is that the plurality of the court in Edna, which was Chief Justice Gleeson and Justices McHugh, Gummo and Hain, did say in paragraph 28 that this test was one of flexible application and that there was no justification for a different test for any other different kind of interest. The second preliminary point I wanted to make is that in applying this test, the court does have a great faith in judges and takes the public to have great faith in judges. In the case of Johnson & Johnson, paragraph 12, the fair-minded lay observer was said to appreciate that the person they're looking at here is a professional judge whose training, tradition and oath require them to discard the irrelevant, the immaterial and the prejudicial. And the final preliminary point that I wanted to make was just in regards to that we are looking at a decision of the Court of Appeal here, and the Court of Appeal applied the correct legal test and came to the conclusion that there was no apprehension of bias here. As the High Court said in the case of Webb and the Queen, the 1994 High Court case, where the Appeal Court has applied this test with the correct principles, and came to its judgment one way or the other, an appeal court should be slow to disturb that merely if they would reach a different conclusion on the facts. It should have to identify some manifest error or some apparent error in the findings. Turning then to the substantive submission, the application of the test here, I will emphasise that this is a two-step test. First, the court must identify what it is said that might lead Justice Harvey to decide the case, other than on its merits. And then second, the appellant bears the burden of articulating a logical connection that goes from that association, from that interest, through to this deviation to deciding the case other than on its merits. And I emphasise, as the court did in Edna at paragraph 8, that the bare assertion of this past association, of this history, without being able to make out that logical connection as a real and not remote possibility, doesn't get the appellant anywhere.
Mr. Barker, you challenging the veracity of what the appellant said? Is that
all I'm pointing to is that it's not enough to merely point to a possibility. It needs to be a real and not a remote possibility. It can't be a speculative. It's not a question of whether there is any possibility whatsoever.
But by saying that, are you challenging the facts which the appellants will put forward? Are you challenging the logical connection between those facts and the conclusion?
The logical connection. It's that logical connection which a fair-minded lay observer must see as a real and not remote possibility. So, for example, as the appellant has alleged, a fair-minded lay observer must see as a real and not remote possibility that Justice Harvey would take into account the appellant's childhood conduct as some sort of character evidence. If they only see it as a remote possibility, that would be enough to disqualify them.
And did learned counsel not just establish a real possibility that this hospitalisation, this violent abuse?
I would submit not. And that's because, taking a step back here, let's look at what a fair-minded lay observer would have to conclude before they would see that there is a real remote possibility. And as Your Honours mentioned, the first thing they'd have to conclude is that Justice Harvey actually recognised the appellant. Because if Justice Harvey didn't recognise the appellant, then he was just any other accused in the court before him.
How would a fair-minded observer come to any conclusion on that matter?
Well, the first thing I would point to, Your Honours, is that Justice Harvey didn't say anything. If he did recognise the appellant, then all judicial training, all judicial tradition, his oath, would have required him to say something. And judges routinely say something. Whether it's the case that they happen to hold a couple of shares in the ANZ Bank, which is partially interested in the case as it was in Edna. Judges disclose these interests whenever they're there.
Well, Mr. Pack, you'll find that the other case that the High Court was considering in Edna, Cleany and the ANZ Bank, the judge didn't disclose his interest there. And Mr. Birch made the submission that the other inference you could draw, or that a fair-minded observer could draw, is that the judge decided, here's my opportunity to get back at this bloke, and didn't say anything for that reason.
Yeah. And certainly that was the case in Edna. I will note that at paragraph 70 of that decision in Edna, the court said that whether or not the person actually disclosed their interest is of evidentiary significance only. It could go one way or the other, as it is here. But taking into account that the fair-minded lay observer appreciates the judge's judicial training, judicial oath, the high regard in which a justice of the Supreme Court is held, and the extent to which such a person would comport themselves in exercising their duties, this court should be slow to jump to the conclusion that Justice Harvey decided to conceal the fact that he recognised the appellant, that he had this history, that he decided to get back at the appellant.
Well, Mr. Packman, Halsby's Laws of Australia tells me that the knowledge of the fair-minded observer therefore does not include any assumption that the judge is capable of putting aside evidence heard.
Well, I would respectfully disagree with Halsby's Laws of Australia and would point you to paragraph 12 of the High Court decision in Johnson & Johnson, which says that a person does appreciate that a judge's training allows him to discard these things and that they are held in this high regard because of it.
Mr. Pack, by suggesting that we should be very, very reluctant to impute any bias towards the judge, and that this standard of a fair-minded observer and their apprehension of bias in relation to the judiciary is a very, very high standard, aren't you undermining the very purpose of the bias rule, in that it's to balance against foul play or vested interests. Isn't that the very purpose of the rule? So by saying we should trust the judiciary, they're judges, they're meant to be professional, they're meant to be rational, you're not really engaging with why this rule exists.
Absolutely, that is an important consideration at play in the rule here. And the respondent does not wish to downplay the importance of seeing that justice is not only done, but seen to be done. But there is the flip side to that, the competing balance that is to be considered. And that is the effect that this has on the use of judicial resources, and also the fact that judges do not choose what cases they decide, they are simply allocated a case, and unless there is a real and substantial reason for them to disqualify themselves, they hear it. Something needs to rise to that real or remote possibility of that logical connection before a judge should disqualify themselves. And as far as faith in the judiciary goes, and the extent to which bias needs to rise before a judge should be disqualified, I would direct your honours to the WA case of Williamson and Hodgson. This was a case where a magistrate was faced with a particularly difficult plaintiff who had been charged with a speeding fine. And the plaintiff came to court and attempted to argue that he had seceded from Western Australia, that the Charter of the United Nations prevented him from being convicted of speeding and various other things along this nature. In the course of that hearing, the magistrate referred to his arguments as complete and utter nonsense several times, started to make sarcastic remarks when he demanded a jury of his peers, such as, "Oh, where are these peers of yours? Do I look them up in the phone book? Should I look for Prince Leonard of 2J?" And then at the end of it, when he finally did convict him for speeding, but before moving to impose a sentence, he said, "I really want to give you life in prison." And yet, the Western Australian Court of Appeal, in that case, held that it didn't rise to that level of apprehended bias because...
But the parties in that case, I assume, had no previous relationship.
They didn't know, but certainly by the end of it, the magistrate had a view, much as the appellant suggests that Justice Harvey had a view of the outcome.
Tenuous argument, Mr. Pack. But if we return back to the core of your submissions, you seem to be pointing to both the fact that there was not a real possibility of bias, and also that this logical connection was missing. So, which of these do you think was weakest on the facts at hand?
To be clear, it's the same thing. The test in Ebner requires that there be a deviation, a feared deviation, for example, taking into account character evidence that shouldn't, or just allowing a person's dislike to influence the decision. And then you have to draw a logical connection to that deviation as a real and not remote possibility from this past history, this past association, these schoolyard incidents. So it's whether that logical connection reaches the level of a real and remote possibility, a real and not remote possibility, that the respondent says is not being made out here. It's the same thing.
And one of the facts in this case, on your submission, not reach that standard?
There's a few things. The first is, as I've said, perhaps the best way to look at it is to step through what a fair-minded lay observer would have to consider, the chain of reasoning that would have to lead to that end result. First, so that Justice Harvey recognised the appellant. Second...
Well, hang on, Mr. Pack, I don't think Mr. Birch has conceded that. Is it a question of whether the judge recognised the events or not, or is the fair-minded observer taken to know some facts, irrespective of who remembers them?
Absolutely. The fair-minded lay observer is taken to, for example, know that these two went to school, but unless he thinks that the judge also knows that, there's no way there can be bias. If Justice Harvey isn't in the mind of the fair-minded lay observer...
Is Mr. Birch submitted that the threshold would be that there must be a chance that the lay-minded observer must know that there is a chance that the justice would recognise the person? But what would you say to that submission? Because you seem to be submitting that the lay-minded observer must come to the conclusion that the judge would have recognised this person. It's a different threshold.
Yeah, absolutely. My apologies if I've been unclear. The fair-minded lay observer must see this overall link, this logical connection, as a real and non-remote possibility. What I'm suggesting is that if they don't see that Justice Harvey recognised the appellant, as a real and non-remote possibility, then that chain is broken in the first step. There can be no logical connection.
So it is your submission then that the late-minded observer would see Justice Harvey's recognition of the appellant as a remote possibility as opposed to a real possibility?
Absolutely, and that's particularly in circumstances where this is an incident which happened in primary school decades ago, where the appellant is just another person who's come before Justice Harvey's court. There's absolutely no indication on the facts that Justice Harvey did recognise him, and this includes the Court of Appeal decision, who presumably had the transcript in front of them, had Justice Harvey's reasons for decision in front of them, and yet the appellant cannot point to anything in any of those or in the conduct of the trial itself, which points to Justice Harvey recognising them.
But Mr. Pack, if we start having the fair-minded observer having to make a judgment as to whether the judge was actually influenced or not, then aren't you severely narrowing the principle, which is in place for justice that you seem to be done?
I'm not suggesting that they have to decide Justice Harvey actually did or did not recognise, just whether it's a real or non-remote possibility.
Aren't you unnecessarily complicating the test? Surely it's looking at the objective facts, then deciding whether those objective facts may give rise to an apprehension of bias.
Absolutely.
You would have us jump through the hoop of the fair-minded observer then deciding whether the judge sitting there knew the relevant facts, and if they knew them, then whether they might have influenced his judgment.
Well, as far as complicating the test goes, I'm doing nothing more than repeating this court's test that has laid down in Edna. Absolutely. This being the High Court, it's open to you to revise that test if you decide that.
Aren't you inviting us to change the test to whether a fair-minded judge would not bring an impartial mind to it? That quite makes sense. But you're replacing the fair-minded observer with a fair-minded judge.
No. What I'm trying to do, Your Honour, is say that before the fair-minded observer would consider that the judge has bias in some respect, or might have bias, they would have to conclude as a real and non-remote possibility that they actually recognise them, that they actually have a reason to be biased. It's just like in the case of Edna, there would have to be evidence-led that the justice in that case actually had shares in the ANZ Bank. If there were no shares, then there couldn't be any interest. It wouldn't be enough for someone to say, well, there might be shares. They would have to show that there's a real and non-remote possibility of there being shares.
But again, it depends on what the fair-minded observer knows about the facts. There either were shares or weren't, and it's a question of whether the fair-minded observer knew of that fact. Here, the judge was either bashed up or he wasn't, and the question is whether the fair-minded observer is taken to have that information.
As far as whether the judge actually had these incidents in the schoolyard, the respondent doesn't dispute that. The only question is whether Justice Harvey actually remembered, or not so much remembered, but recognised the appellant who came before him. That's the critical issue in this case, and whether that's a real and non-remote possibility. The other point I'll make is that even supposing the appellant got past that hurdle and a fair-minded lay observer would see that as a real and non-remote possibility, there's a question of what happens next. This was a schoolyard incident more than 20 years ago. It's not at all clear that Justice Harvey would have held enough of a grudge against the appellant to sentence him for life imprisonment, regardless of what the evidence in the case actually said. The other point to make is that, as was demonstrated in the case of Williamson and Hodgson, that judges are expected to put aside the irrelevant, prejudicial, the immaterial. So, for example, in a judge-alone trial, if an application to lead certain character evidence is made, and the judge rules that that evidence is not admissible, the judge doesn't have to then disqualify themselves because they've made a ruling on that. They would simply go on to hear the case and discard that, and the justice system expects them to do so.
Mr. Pack, isn't that different though from having an interest in the case or having a personal connection to the subject matter?
It's in the same ballpark, Your Honour, and I note that the appellant characterised the nature of the influence as possibly being a sort of character evidence at one point.
Mr. Pack, pretend for a minute you're the defence lawyer for an accused, and you're going through the process of jury selection, and you know that one juror has previously been bashed by your client. Would you object to that juror sitting?
I would.
And why?
Because I doubt that the pleasant towards my client? Of course, that's a different question here, because there are differences of facts. Again, it's not clear that Justice Harvey recognised it.
Put aside your argument as to memory.
Yes.
Let's be as fair to the appellant here as possible. Put that aside.
Okay.
Assume that the judge did remember it.
Yeah.
What's your argument now?
My argument now would be that a justice of the Supreme Court should not be seen to sentence someone to life imprisonment to avenge a schoolyard slight. They are taken to be able to put aside the immaterial, prejudicial. They are taken to keep in mind that their oath requires them to do justice fairly and impartially. And
it's severely narrowing the principle, though.
Not at all. The principle is as it is, that there must be a real and not remote possibility. I can do no more than submit to this court that there is not a real and remote possibility that the appellant has established on the facts today. Unless Your Honours have any further questions?
Yes, Mr. Back. Just by way of example, there's a federal court case, Kobe and Sudu, where a judge disqualified himself on the basis that he was a member of the same Queensland Debating Society as one of the parties before him, that he knew one of the parties, that he was actually quite good friends with one of the parties. Now, if that's enough to disqualify a judge on that basis for a friendly relationship with one of the parties, why is it not where one of the parties has previously bashed up a judge 20 years ago? Why is this not enough to disqualify the judge?
There's two answers to that, Your Honour. The first is that, as was noted by the court in Ebner, even though judges might only have to disqualify themselves once there's this real and remote possibility, in practice they tend to disqualify themselves as soon as there's any hint that there might be such, because justice should be seen to be done. And the second point is that here, again, there's the hurdle to get over whether Justice Harvey even recognised the appellant, which again makes it a very different circumstance as to whether he was prejudiced in the first place or not, whether that might be seen as a real and not remote possibility. Unless you have any further questions? Thank you, Your Honours. Well, that was fun, guys. This is my own fault for stacking the bench with people when you would ask a lot of questions. That's a lot longer than I meant to.
Time?
Oh, let's not ask that.
Yeah. I currently didn't push start.
Having said that about questions, does anyone have questions at the end of that about what you thought of it?
Yeah, judges usually that harsh.
No, sometimes.
Let's sit down.
Yeah. Sometimes you get judges who, like Nigel, are activists. Sometimes you get judges like Nigel who really won't let you get away with a point and move on to other things. Sometimes you get judges like Nigel who you really shouldn't put on the court.
Well, hang on. They're not always nice and pleasant. I had that grand final a couple of years ago. Justice McKechnie, first thing I stand up and say, "Good evening, Your Honours." I thought it was being nice and pleasant and polite. He said, "Never to say good evening to the court." And that's how I started my submissions. So I think I was being reasonably nice and pleasant to you guys.
I think the answer to that is you do get a variation in judges you'll see. Sometimes they want to have a conversation like we had today, and in some ways that actually helps you out quite a lot because that lets you know where you should go and what they actually are confused about as well. So it can be helpful. On the other hand, you certainly do get judges who are willing to let you walk them through it. So they want to know what your structure is because that's probably something you've thought about for a while, so it's going to make more sense to them that way. And they'll jump in when they're confused about something to ask for clarification or to put something to you, but they'll intervene a lot less. It is a lot up to the style of the judge. Having said that, if you're taking on first-year mooting, for instance, then generally nowhere near as interventionist as this, unless you get ranked clients. But beyond him, it's generally about helping you through your submissions and engaging with what you're talking about as well. Judges are actually, and I think in this case as well, are genuinely interested in what we're talking about. They want to understand and know. So that's why they'll ask lots of questions or will come in at times when they're not certain about things.
It's also not necessarily a bad thing. It means that if they're asking questions, it means they're paying attention and they're asking questions on the points that are legitimately in contention or are unclear. And if you're prepared, then you'll probably find that actually like being asked questions because you probably have the answers to them. And if you don't have the answers to them, there's all sorts of ways you can do to get around it. Like Sam saying, I just don't know. And that's a line of inquiry.
Not the best answer.
Well,
Sometimes
it's a fair answer. You know, if you don't know, you can't be expected to know everything. And that just shuts up the judge because they can't keep asking questions about something you don't know about.
I think that about answers it, hopefully. Sometimes they'll be bad, sometimes they won't. Good luck. Anyone else? Hopefully that doesn't scare them.
How would you guys have found on that?
Definitely no.
If you want my bias in question, cover it up.
Probably like something else that's worth mentioning as well. I don't know which judges do this. I'm pretty sure it's not entirely convention, but some judges will do like a mini judgment on the case, and usually because these cases are so weighted towards one side or the other, that like it'll be obvious which way it'll go, but that actually has like no impact on who won the moot, right? I mean, like you can have people who clearly have like an awful side going, and they just have to make completely points which are like bordering on bullshit, or like even bullshit points, and like they can still win because they just make themselves actively,
They'll give you points for trying.
Yeah. It's nice to have a hard side actually, because if you've got the easy side, then there's not much you can do with it to show that you've done anything more than what was expected.
I actually really like having the hard side. That's why I set myself up for these things. Alright, your turn.
Some of you know who I am because I'm a lecturer, and some of you don't. So I am a junior lecturer here, but my main claim to fame is that I am the Moot coach, and I have coached the team twice now. And as an undergraduate student, when I was doing my law degree, I was a member of Murdoch University's inaugural Moot Court bench, so we set that up. And then I was my last year, I was in the grand final, and then in the grand final of the senior mooting competition for Murdoch University's mooting comp. And I lost to my best friend who I had so far beaten twice during the competition, so we got that in the score. So a huge part of mooting is asking questions. We've just had a lovely demonstration of that process. You give a start to give your mooting, and at some point the judge will interrupt you. A moot is never going to be straight, here's my talk, blur. Unlike occasional lectures where I get a quiet class. It doesn't happen very often. Moots will almost always have engagement. In fact, the moot you don't want to have is the one where the judge says nothing. Yes, it will occasionally happen and you need to be prepared for it. But that's a bad moot. That's a moot that you're going to come out going, don't do well, don't do badly, I have no idea. It happens sometimes because judges are inexperienced, judges are tired, they don't know the area, or they're just trying to give you a hard time. Just occasionally we'll do it to you deliberately because we want to test something. That's more likely to happen in an international mooting competition where one of the judges on a panel and one will be silent and they've made a decision, they're testing something. That something's been going weird during the comp and they want to see what happens. But it's not as common in internal mooting comps for that to be the case. More likely if you get a silent judge, they've just been all day on the terrace, they're tired, they've read the problem for 10 minutes, and they're just blanking. So, unfortunately, it does happen. But most of the time, you will get asked questions. So the first thing is, why do we ask questions? What's the point? What's going on here? Why would they bother to interrupt what is otherwise, I'm sure, a wonderful presentation? And there's a whole heap of reasons. For a start, it's part of the marking criteria. Most mooting competitions will have one of the criteria, ability to answer questions. They've got to give you marks. They can't give you marks for something they haven't tested you on. So you're going to get asked questions purely for that basis. And so sometimes some of the questions will be really procedural. And I'll have a chat about those in a moment. Makes them a bit more interesting. It's interesting for you, but you've got to remember many of your judges have worked a long day on the terrace. They're tired. If they just sit there quietly, they're going to sleep. And so they're going to be asking you questions to make this interesting for them. And actually it's a good sign. If a judge asks you questions, they've heard what you've said. They're interested in what's going on. So it's a very good sign. So maybe purely they're interested and to make it interesting for them. It's also a really good way to challenge and see how good your mooter is. So you can ask questions to see, have they done their research? Do they know that in the case they just cited, there was a dissenting judgment? Do they realise that there's a case that's exactly the opposite to their point but distinguishable? If I bring it up as the judge, I'll see how well they've done their research. So it's a good way of testing that level of research, testing how well the Moot's prepared. It also breaks things up a bit. So sometimes what we're testing is not your level of knowledge of the content. I want to see how flexible you are. So if I'm asking you a question, I might be deliberately going, hang on a second, I want to go back to that previous point. Or I might see in your written submissions that you were going to head somewhere. So I'll ask you a question deliberately on that somewhere to see if you can go there. Do you know your material well enough that you can jump all over it? Or are you rigidly fixed to a prepared speech? So I'm testing that ability. Sometimes, unfortunately, they will ask a question because they don't know what you just said. That can be one of two things. They weren't listening. That does happen. But more likely, it's you've not perhaps explained yourself as well as you could. So if you get a question that was, but I just said that. Didn't I just explain that? Chances are you didn't explain it as well as you could. That's not a great sign to start with, but it's given you the opportunity to re-explain yourself. So again, it's another opportunity to take. Most of the time, being asked a question is a good sign. It means the mood's going well, things are going along. And sometimes it'll even be the judges helping you out. I had that in the grand final of the senior mooting competition. I had a shocking day that day, where I had spent all day doing student politics things and meetings, in and out of meetings all day, trying to prevent the law school being lumped in with business school and the new faculties. I lost that debate. It's okay. Got over that. But I spent all day doing that in the day of the grand final of Mooting. And one of the judges knew that had happened to me all day. So they knew that my ability to have read all the cases wasn't good, and he could see that I was struggling to enunciate my point. And so he asked me about a case that he knew I should have read. I'd read the summary, unfortunately. Never do that. And so it didn't work out, but you can see what he was trying to do. He was trying to assist me to help me get back on track. And particularly where you're floundering, if you get an experienced judge, that's what they'll do. They'll actually see you struggling and go, oh, okay, hang on, I'll ask a question to clarify, to help get you a chance to re-explain and help you along. That's particularly going to be the case for those of you going into the junior mooting competition. Junior mooting's not about frightening the hell out of you. It's about teaching you. So the judges may very well be asking a question to try and help. So that's why they ask questions. What do they ask? First type is the procedural, the mechanics questions. Do you know that there's a dissenting judgment? So you are, counsel, are you aware there was a dissenting judgment? And your response is, yes, Your Honour, it was from Justice such and such, but they weren't to dissent on that point. Those sorts of questions. They might ask, well, what court was that from? Because why do they ask that sort of question? Well, if the court is higher in the court hierarchy, it's binding on them. If it's lower, it's not. So a judge, that's the sort of question a judge would legitimately want to know the answer to, but it's also a way to ask, did you do your research? Did you check? Are you actually giving me a binding case? Has that case been followed? Questions like that. Were the judges in dissent? What court? Can you take me to the page of the judgment you're referring to? So if you're referring to a particular law, you need to know what page the judgment's in. Just like when you're citing in an assignment, you should know it in the Moot. You might not say it when you're doing your presentation, but you need to know it, because the judge will ask you those sort of mechanical questions. They're designed to just check you've done the basics. You've actually bothered to read the case you claim you know. You've actually done some basic research. Those are the mechanics questions. And if a judge isn't familiar with an area, they're the default comeback. So the people coming off the terrace, that's your default comeback. And that's what I tell junior judges, people who are first time to judge, they come and say, what do I ask? Well, that's the questions you ask. They're the basics, because you don't actually need to know the area being discussed to ask them. Then there's application questions. So they're actually trying to get you to link the facts that you have with the law. So they'll talk about the facts and ask you about facts. So, but counsel, in the facts, doesn't it say X? What they're trying to do is to get you to apply and discuss the application of the law you've been presented so beautifully with the facts. So then again, it gives you an opportunity to do that discussion. So that's another type of question they ask. They also ask clarification questions. So, do you mean X? Sometimes the answer is, yes, Your Honour, absolutely, that's exactly what I mean. And sometimes it's, no, Your Honour, and re-explain. That, just because they ask a clarification question, do you mean X, and your answer is no, Your Honour, doesn't mean they misunderstood you. Sometimes it simply means they're trying to see if you were listening to them, because one of the things that's very tempting to do is to always agree with the judge. Sometimes the judge wants you to say, no, Your Honour, actually what I was meaning was Y. Because agreeing with the judge is a trap. Sometimes they're wrong. And sometimes they're deliberately, they know they're wrong. They want to know if you know they're wrong. And the final type of question, hypotheticals. So are you saying that in a situation like X, which is different to the fact you've got, Y would happen? So why would you ask that? It's not even related to our problem. Why? They're trying to test the logical extension of the proposition you're making. The thing about mooting is we're arguing on points of law which are in the grey zone. That it's not clear, that sometimes the outcome can lead to absurdities if you take it to its logical conclusion. And sometimes that would mean that's just going to be wrong. But I want to see, have you thought that through? Have you thought through the logical extension of your arguments you're making? So I'll ask you those hypotheticals and try and put you right on the edges. So this year's Jessup team, I was quite famous for asking them, so do you mean that we have to have committed genocide before they can complain about it? The point being, in this particular argument they were making was effectively had to have a very, very high level of human rights abuses, and I was trying to suggest to them that the logical extension of their argument was you could never complain about it because the people who complained were dead. But I was asking a hypothetical to try and push the logical extensions of their argument, and they were able to bring it back in. Well, actually, no, there's a limitation to what we're saying. So it's testing where the boundaries are. But what you really want to know is what do you do with those darn questions? How do you answer them? First thing, don't panic. You need to take a moment. If you don't know the answer off the top of your head, sometimes you will. If you prepared really well, and you're lucky that, like me, you have a very, very good memory, you might know the answer like that. Most of the time you won't. It's a good chance to take a breath. It's okay to take a moment to think. If you're nervous about leaving a gap, or you know you can't do it yourself, take a little sip of water. We used that great effect in the curve with one of our mooters was losing her voice, in fact. So every time she was asked a question, we told her to take a sip of water. And we got comments throughout that she had such poise and dignity. We were hiding the fact she had her voice. And then she kept talking the entire time. She wasn't going to last out 20 minutes of the moot. But it worked. It slowed her presentation down. It made it look really dignified, the fact that she was taking a pause. Be prepared. You are going to moot on this little bit of what you have prepared. You need to prepare all of this. You need to have read the cases. You need to have read the commentary. So that's your textbooks, that's Halsbury's Law Online, that's first point. You need to have read that commentary on your particular area of law. You need to have read the cases that you don't intend to refer to but are relevant in the area. You need to know your stuff. Because if you're prepared, then you can go to that stuff even though you didn't intend to. You intended to say this bit, and then the judge asks you about a bit over here. Well, if you've already prepared it, you've read, at least read it a little bit, you can refer to it. One of the biggest challenges is details. Who can remember what the name of the dissenting judge whose judgment isn't even relevant is? Unless you've got my memory, it's not going to happen. So you need to think of a way to deal with that. The way I used to deal with that, when I was particularly where there was a lot of cases, was I created a cheat sheet, 1 page. And on that cheat sheet, for every case, I have the name of the case, the court, the name of all the majority judges, and indicate if they were a joint judgment or single judgments, the name of any dissenting judgments, a very brief summary of the facts, and then dot points of the key points from that case with page numbers. So I could then, for the things that I thought I was most likely to get asked about, simply turn to it in my file. There it was, case. I also had, at the Moot, always a printed off copy of every case, highlighted any passages that I thought I might need with tags. 9 times out of 10 I never touched it. But on that one occasion that there was a quote that I had used, and I couldn't remember the page number, the quotes were already highlighted, so chances of me finding it were pretty good. But usually all I needed was those page cheat sheets. It has those nitty-gritty details that look really impressive if you know them, but you're not likely to remember. Engage, but keep it short. You've prepared all this beautiful material that you want to present, yeah? So don't waffle in your answers to the questions. Even better, make your answer something you're prepared to say anyway. So if you haven't prepared it, keep it short to the point, move back to your submissions. Your Honour, it was in the High Court in 1973. Now, turning back to those, keep it short, keep it snappy. Where it's a longer question, short as you can, back to your submissions. If it is something you're prepared to say later, move to it. Just go there straight away. But don't tell the judge that's what you're doing. If you tell the judge and make a big fuss about, oh, I'm moving over here, you'll get marks for being flexible, but you lose marks for not actually answering the question, because then the judge is ticking in the mind going, but are they answering my question or are they just avoiding my question? If you can answer the question with prepared submissions, do it, just don't tell them about it. Yeah? Unless, there's one exception to that, unless you have decided that your methodology of mooting is going to be moving them around your written submissions. And if you need to do that, then you say, Your Honour, in answer to your question, may I direct your attention to page 5 of my written submissions, point 3, and then to answer the question. That if that's your method, that's a method I have used, then that's one exception to that, telling them you're moving somewhere else, because obviously you've got it there and that is going to assist you. Always be polite, courteous and friendly. Don't get snippy with your judge, even if they're being, to put it bluntly, a pain in the ass. Because sometimes judges will get a pain in the ass deliberately. I have a reputation at Kirby Moot for being a pain in the ass. I also have a reputation at Kirby Moot for staring at mooters and staring them in the eyes the entire time, which they think will tend to get a bit snippy about. But don't. You need to be polite and courteous. No matter how nasty and snippy your judge gets, you have to take the high ground because you're the mooter. Also, don't tell the judge it's a good question. The common one you get all the time. That's a very good question, Your Honour. They know that. They asked it. By definition, it's a good question. So those sort of platitudes, well, I was just going to come to that, Your Honour. That's a very good question. That's very interesting. Don't need it. The judges know it was very good and very interesting. By definition, they asked it. So you don't need to reassure them of their own egos. If you don't know the answers, don't make it up. I have seen that happen in a moot. It is disastrous. If you don't know the answers, sometimes you have to be honest. Sometimes you can take a moment, think through all the research you've done, and think about the way the law works and the way it logically works. So, Your Honour, I don't have a case that's directly on point. However, from X case that I have got, this isn't. So you can do that. But sometimes, ultimately, the answer will be, I'm sorry, Your Honour, I can't assist the court any further on that point. Not I don't know, but I can't assist the court. Or Your Honour, I'd be happy to make written submissions on that after, which is more how that would formally and realistically happen in a real court. You'd say, Your Honour, I'm afraid I don't have the answer to that with me right now, but we're happy to make a written submission on that point later. That's how it would really happen. Okay? Finally, changing of style. One of the things we used to love, and Sam is a classic of this, we all waited for Sam to get his first question in the Kirby Moot, because after that he settled down and he had a nice style. Yeah? One of the things that's really obvious when you're mooting is people change their style between when they're giving their prepared, memorised presentation, and when they're answering a question, they suddenly become more lively, more personable, more approachable, more friendly, more interesting. And then they go back to their prepared speech that we're going to do in monotone exactly the same all the way. It's a challenge. You need to try and even that up. So it's not obvious that you're switching all the time. Ideally, usually, your answer to question style is the better one, usually. So it's a hard one to do. One of the ways to practice it is, I'm afraid, using a mirror and getting somebody who, you know, two of your friends perhaps come over before a moot, for a competition, prepared. One of you sits so you can ask questions, the other gives you speech into a mirror, person asks a question, and watch yourself. Watch how that changes, how your demeanour changes, how your expression changes, and then try and imitate what's happening when you answer the question for the rest of the moot. It's actually better to go that way try and imitate the more formal style when you answer the question. Because when you answer the question, you're being you, you're being natural. And that's usually more successful. Which I think brings me to the last of the points I want to make. So does anyone have any questions for me? We'll stunned you into silence.
What were the facts in that case?
I haven't got a case. Give me a case and I make it find some facts. I'll make some up.
I've often found when I mooted that the procedural details, especially in the like open mooting comms, for instance, and at that level, like they just almost never came up. And it's kind of gotten to the point now where I almost just don't really bother to like prepare that kind of stuff. Like I kind of make a note of it in my mind.
Things like the case and those, where the court.
Yeah, it's just like who were the dissenting judges and like what were the exact facts. And
the difficulty is it shouldn't come up in a good mood.
Yeah.
In a really good, well-prepared mood, the judges know their stuff, it shouldn't come up because they should be able to ask you more detailed questions about the law, about the content, about materials. The difficulty is the one day you don't prepare it is the one day you get that judge who's done no preparation. And certainly it's something that changes as you go through mooting. So in junior mooting, you also expect those sort of questions because they're easy. We know as the judge, they're an easy question. It's a question you should know the answer to, and it's a gimme. We're giving you a gimme, but as you get through the ranks, we're not going to give you gimmies anymore. In fact, one time I will ask those questions in more senior mootings when I know you don't know the answer. A classic one that I do is in international competitions. It's quite common to refer to the work of eminent scholars, and you're permitted to do that in international law. But you're only permitted to do it if they're an eminent scholar. And often the mooters haven't done the research behind why they're an eminent scholar. They don't know where they're from, they don't know what their major publications are. They can't justify they're an eminent scholar. And in the International Maritime Moot, I pulled Sydney University up on that, referring to one of my professors at the university, and so I knew the person they were referring to. And I was able to, the only reason I asked that mechanical procedural type question, because I knew they didn't know the answer. I could tell they hadn't done the work. So at the junior mooting stage, you'll be asked those questions because they're trying to give you a gimme. If you're asked it at the more senior mooting stage, they think you don't know the answer. And they're trying to just be sure that you really are right, that you don't know what you're talking about. Other questions?